These days, we are hearing a lot about actions in India against people who are using social media or the electronic platform. We've been hearing about cases, how people tweet certain things and immediately the police registers some cases against them. This is all thanks to the Indian Information Technology Act 2000. One particular section has come into great news and controversy these days, and that is Section 66A of the amended Information Technology Act 2000. This is one particular section under which a number of people have already been arrested and bailed out, and criminal proceedings are pending. Recently, we saw the case of Mr. Karthi Chidambaram, the son of Indian Finance Minister, who had reported a complaint against a person who had used the Twitter for the purposes of defaming him, and a case in this regard was registered. Clearly, when you look at Section 66A, it is a Pandora's box of problems. Why? Because it uses words with huge dimensions which are capable of distinctive subjective interpretations. For example, you need to be careful because 66A says that if you send any information in an electronic format, either through a computer system or a communication device that's grossly offensive or has menacing character, then you are in trouble, because that is an offense under Section 66A, punishable with 3 years imprisonment and fine. Further, if you also see that you send using a computer or a communication device any information that you know is false, but you send for the purposes of causing annoyance, inconvenience, hatred, ill will, enmity, clearly that's also an offense under Section 66A. And thirdly, if you send any information using a computer or a communication device which aims to mislead the recipient of an electronic mail message about the origin of such electronic mail message, that is also an offense. So these parameters are huge. Anybody can say that the information that you tweet or you put on your Facebook wall is grossly offensive or has menacing character. Anyone can argue that the information that you can say is false but has been said for the purposes of causing annoyance. How do you define annoyance? It's so vast. How do you define inconvenience? How do you define ill will, hatred? These are huge words, and thanks to these huge worded provisions of the IT Act, this is capable of so much distinctive abuse in various circumstances. That's why we are beginning to just see and scratch the tip of the iceberg. We are going to see more and more cases where Section 66A of the Indian Information Technology Act 2000 would be invoked for the purposes of initiating criminal proceedings. It's high time the Government of India woke up and looked at how to narrow the parameters of Section 66A and how to ensure that this provision does not become a tool for potential abuse in the hands of the mighty and the powerful.